Saturday afternoon, here I am, weekend appointment with Carl Rominger. I'm going to answer your legal questions. 540-0580. That's 540-0580. And call in now, and I will answer your question on the air. Obviously, we keep it anonymous. I don't want to know the name of your nosy neighbor, your deadbeat son-in-law, your horrible ex-wife, or whatever great thing you want to call a lawyer about. Do you ever notice that? You never go to see a lawyer usually when you're happy. It's usually, nobody comes in and says, how do I get a marriage license? They always come in and say, how to get a divorce.
Isn't that in your job description, though?
For the most part. Once in a while we do adoptions, though, Shane, and that does make people happy.
That's very nice of you, Carl. Very nice.
What I want people to remember is to go to weekendappointment.com and post questions throughout the week. In fact, I've got a slew of them I've got to catch up on now. I'm going to do some of them on the air, and I'll be typing responses to the others. But I did get somebody that wanted to know, is it, in light of a recent PA Supreme Court ruling, I began to wonder, the state law that allows you a refusal to submit to a breath test or blood test for DUI is punishable by a license suspension. The court says it's part of the evidence gathering, so you can't invoke your constitutional rights. Is it constitutional? And the answer is the courts have uniformly said yes, they can enhance your punishment for refusing. You can also lose your license under a civil license suspension. And so the important thing is, if you're asked to do a breath test or a blood test, usually the best legal advice is to submit. Usually. I can think of scenarios where it wouldn't be, but I doubt you're going to be able to make that call in the booking center on your own. So as a general rule, I would usually recommend submitting to a blood or breath test because of the enhanced penalties and also because of the separate civil penalties that apply. So while lawyers will continue to test the constitutionality of it, in the meantime, the rest of us should submit whenever we can, unless we've studied the issue. And so I always tell people, submit to that chemical test when the police officer asks you. Now, you don't have to submit to the roadside breathalyzer, but that's a whole different story. Stan, you're on WHP 580 with Carl Rominger. What's your question?
Hi, Carl. A friend of mine was recently involved in a minor accident, and he did not have any car insurance at the time. He was fined, and he was told by the officer that he was going to lose his license. The officer didn't indicate how long. He called PennDOT. PennDOT, he apparently didn't have the right area, didn't get an answer. Do you know how long typically one would lose a license in such a situation?
I think, and off the top of my head, I don't have my chart in front of me, but I think failure to maintain financial responsibility, I think, is a 60-day or 6-month license suspension. I can't remember which one it is.
Okay.
Usually, though, when people come in with one of those, there's two possibilities. One is you simply just never bought insurance. And that's going to be a hard one to argue for leniency on.
He did have insurance, and he let it expire.
And the next question is how far expired it is. A lot of police officers and district justices, if you can show that you promptly got insured after the accident and you have a colorable argument that maybe you didn't realize it was fully expired, they expired 5 days before the accident, 15 days before the accident. A lot of times we can work it out and plead to something else so there's no license suspension. If you've been out of insurance for 6 months, I think rightfully so, a lot of police officers are going to take the hard line and say, tough nuts.
So it's not going to be more than 60 or 6 months based on your recollection?
Yeah, based on my recollection off the top of my head. Now, I know it's not a year. The other thing I would tell you, though, is it is worth negotiating with sometimes, even if you were a long ways out. Sometimes you can find a sympathetic person. And I want to, Stan, while I got you in the air, I want to tell you about one other problem we see that happens very frequently. Mm-hmm. Let's say you change insurance companies. The way PennDOT does it, when I cancel with, Progressive, and I take up State Farm. If I cancel with Progressive, they send a letter to PennDOT that says, hey, Rominger doesn't have insurance anymore. Mm-hmm. And then State Farm sends them a letter and says, hey, by the way, PennDOT, Rominger got insurance on this date. So PennDOT's computer looks at the two, and they see that you were, kicked out on the 5th, and you had new insurance in on the 10th, effective on the 4th or the 5th, they go, okay, he was never uninsured.
Okay.
But here's what happens. Once in a while, the guy at Progressive's a little slow sending the letter in, right? Mm-hmm. So State Farm's letter gets there first. So what PennDOT does is they ignore the letter from State Farm because you're already insured. And then they get the one from Progressive that says you're canceled or you canceled your policy, and they show you as uninsured. So that's a common one where people will show as uninsured in the system, or get a notice from PennDOT saying that, they're not maintaining financial responsibility. And so I just point that out is if you're confused as to how that happened or you swear you had insurance, you just might.
Well, he said that he let it lapse in January, so it's been 6-7 months.
Yeah, he might have to take his lumps.
Yeah. Okay, Carl.
All right, Stan. Sorry I don't have a better answer than that.
I appreciate it.
Talk line number here is 540-0580. That's 540-0580. This is a show where we answer your legal questions. I just want to take a moment to tell you about a new area on weekendappointment.com. We have an announcement section, which you're going to find up near the top under questions for Carl and before the registered users area where you get your free will. And the first one we have up is the 2009 Central Pennsylvania Friends of Jazz 2009 Jazz Picnic. That's going to be on Sunday, August 16th, 2009 from 1 to 6 at the Seibert's Picnic Grounds in Bressler, PA, which is just south of Harrisburg. Folks, that's a great event. I've been there many years. It's a family event. They do have beer, but it is a family event. They have, there's about 5 or 6 different acts that are going to be there. They're all jazz. It's all very nice. Again, it's like a family-style picnic. A lot of people come in groups, bring dishes to pass. You can get tickets online. If you go to weekendappointment.com, you can find the announcement on that, as well as their website, which is cpfj.org, which I have a link to. Again, from Weekend Appointment in the announcement section. So if you have an organization that's doing a special event and you want to send it to me for my consideration to see if we want to put it up and let people know about it, we will. Take another question from weekendappointment.com. If a state worker is hospitalized, now you guys are going to like this one. If a state worker is hospitalized because of stress that was created from not getting paid, is the state worker eligible for workers' comp? The state worker in question was taken from the job by ambulance to the ER. The ER said it was a panic attack caused by stress and anxiety of not getting paid and financial problems the worker will incur from not getting paid. I'm not sure the ER said that's exactly what it is, but the ER apparently diagnosed this unpaid state worker as having stress and anxiety, and was that an on-the-job injury or job-based injury? I don't know the answer to that one. This whole state worker crisis is creating all kinds of interesting legal questions. Can the governor pay the workers? The lieutenant governor says you can. Can the banks take IOUs, like California is doing? These budget crises create all kinds of unusual situations. And I'm not sure that a panic attack caused by stress of not being paid, because you're going to get the money again later, theoretically. I don't think our state's going bankrupt. That's California that's going bankrupt. So I'm not sure. I don't know the answer to that, but I like it. It shows you're thinking. I have another one here. Somebody has a street drain problem. I live at the bottom of a hill in either direction. When it rains, the existing drains cannot accommodate the runoff, and then it floods, and the township says, well, it's going to be too expensive to fix. You can always work with the township on that, potentially sue the township. I remember doing one of these years ago, where we got the township involved as well as some neighbors, and we were able to reach a resolution by agreement. Lonnie, you're on WHP 580 with Carl Rominger.
Hi.
Hey, what's going on?
Oh, not much working. Carl, is it a simple will if you say sell everything and here's 6 people and here's the percentage to give them? Is that a simple one or no?
Yeah, that's a fairly simple will. Usually, you can direct everything sold. Usually what you say is, I divide my estate between the following 6 people, and if you want to give them percentages, you can do that. There's a couple other questions about, how do you want, what happens if one of the 6 people dies? Do you want the rest to go in different shares to everybody else? Do you want us to, are you giving them all 1/6? And if one of them dies, they get 1/5, or does it flow down to their kids? I mean, there's some questions like that you probably need to answer.
Well, all right. I never give that a thought.
Yeah, that's why, Lonnie, and that's why we lawyers go nuts when people write their own wills. I got one in court right now where the guy kept referring to grandkids. Well, guess what? He lived with a lady for years and years and years and years and years. And as a result, she kind of considered herself the wife, and her kids had kids. And so, she says, well, we always refer to all the kids as the grandkids. And so my grandkids could get some too, but on the other side, his biological grandkids are saying, hey, we're the grandkids. So, that's the kind of thing a lawyer would ask you to, what do you mean by grandkids? What's your family situation? So that's why I have so many questions I ask people when I do write a will for them, not so much for what's going to go in the will as so much as how we're going to write it to make sure it does what they want it to do.
Right.
So,
okay, thanks, Carl.
by the way, Lonnie, you can get a free will if you go to weekendappointment.com. You sign up, go to the registered users area, and anybody listening can do that. And then you send in the sheets, and then you and I meet, and we answer all those questions, and you get it for free.
All right. Yeah, I've downloaded the form. I just haven't filled it out.
Yeah, all right. Fill it out and send it in. Jen will call you and get you in the office.
All right. Thanks, Carl.
All right, Lonnie, got to go into break here. Folks, WHP 580, Carl Rominger answering your legal questions. We come back from the break, 540-0580. That's 540-0580. Welcome back. Carl Rominger here answering your legal questions. 540-0580. It's 540-0580. I'm going to take some more from weekendappointment.com, but let's grab Angela here on the phone. Angela.
Yes. Hello. How are you?
Good.
Good. I was wondering how long can a company bill you for a service if they haven't billed you, before?
How long do they have if they've never billed you before?
Well, actually, okay, Comcast is saying that I have an outstanding bill from 6 years ago that I have no knowledge of that I dispute.
Okay. Well, if they're outside the statute of limitations, they're in trouble. And usually for contract, for services and things like that, 4 years from when you failed to pay.
Right. But actually, they not only did they bill me, but they transferred. I have a current account with them, which I had for quite a few years. See, what happened is I moved out of my one residence and I moved in with a boyfriend who already had cable. So, and then once we split up, and then I needed to get the service again, and there was no mention of an outstanding bill at that time.
Right.
And then all of a sudden, I get a letter in the mail stating that I have an outstanding bill, and that they transferred it onto my current account. And I was like, I mean, out of the blue, I was like, what?
Right. Well, they may have no legal recourse to collect that old amount due from you. I think they could say to you, you know what, we're not going to give you service going forward. I think they might be able to do that. But then again, they're kind of a monopoly, unless you count satellite and all that kind of stuff. But I would suspect that a firm letter from you saying, I don't know what you guys are talking about, I dispute that portion, you might be able to get it fixed.
Oh, well, I spoke to like 3 different people on 3 different occasions, and I asked for my old statements.
Right.
And they gave me a partial ledger and told me that during their research that they found that I am responsible for the old amount and that they couldn't give me old statements because they didn't have access to them.
Yeah, what I would do, and again, you talk to people on the phone. And here's what I always tell my secretaries. After you get off the phone, if you did talk to somebody, memorialize it with a letter to them because words just disappear into air. Send them a confirmatory fax if they promise you something or tell you something. So I'm not a big fan of phone conversations as documenting your dispute. Make sure you dispute these kinds of things in writing.
Okay.
Send it, return receipt requested. Keep a copy of what you sent because I go nutty. People come in, they're like, yeah, I sent a letter. I'm like, can I see a copy of it? And they're like, oh, I didn't copy it, Carl. I didn't think about that. Well, you know what? You got to copy stuff so we know what you sent them, so we have some proof. And you send it registered mail so that we know that they actually received it. And do that to lay out your dispute. A lot of times written correspondence also gets you past what I call the frontline operator.
Okay.
Try that.
Okay. And my second question is if I would disconnect service and pay what I feel I owe them, which would be, my
for the current
monthly. Right. Can they report that on my credit report?
They can, and then you can dispute it.
Okay.
And then you have a fight over whether you actually owe the debt or not. Complex thing here is they're going to claim you somehow reaffirmed the debt by taking over a new account with them. You're going to say, no, I didn't because I didn't think I owed you anything at the time I did this, so that was not a reaffirmation. But you have actually a complex little legal problem on your hands.
Oh, my God. It's a frustrating one.
How much money are we talking about?
$177.
Yeah, well, it ain't worth hiring a lawyer for $177.
Okay.
All right?
Okay, well, thank you so much.
All right. Good luck, Angela.
Okay, thanks.
That's another problem. $150. I had somebody in the other day, and they had a dog, and the dog got adopted off. Long story, and they were trying to get the dog back because they didn't adopt the dog off. Somebody they gave it to who was supposed to return it. Well, so they finally tracked the dog down, and the adoption people said, well, you need $200 to get the dog back. And after I entangled all our legal rights, I said, you could probably sue to get this dog back, but for what it's going to cost, you might as well just pay him the $200. That's the problem, folks. Sometimes justice is more expensive than just throwing in the towel. Ray, you're on WHP 580 with Carl Rominger, 540-0580.
Hello. Thank you for taking the call. I have a question about if someone who is a beneficiary to a will and they violate one of the clauses on that will, what can be done about with the other beneficiaries? Can another beneficiary on that same will do something about this continual violation?
Well, the short answer is yes, although I'm wondering where the executor is in all this. In other words, what do you mean by violating the will?
Well, say a spendthrift clause about encumbrances.
Okay.
In the will, and another beneficiary just keeps violating this spendthrift clause and keeps using this as and doing the encumbrance against the real estate property that is multiple owned. And
well, the short answer is you as an heir or a potential heir would absolutely have the ability to ask the estate to enforce that clause, and if the executor or executrix is not doing what they're supposed to do, then the beneficiary can either get a court order compelling them to do it, or could even potentially replace them.
Well, then it's the executrix or the executor's duty then to have that clause enforced. Well, that's the question. What if the beneficiary just keeps ignoring this part of the will?
Well, that's what I mean. The executor or executrix should enforce whatever provisions they have the power to do. And if they're asleep at the stick, one of the other beneficiaries can step in and say, hey, court, exercise your supervisory role over this numbskull who doesn't do what they're supposed to do, and make them do it or replace them.
Well, say I was the executor, executrix, and I find that another beneficiary is making like unpaid property taxes that they didn't pay, and makes the other people that are on the will as beneficiaries make them pay their share.
Well, I'm not understanding something. Is how old is this estate? Is it closed up yet?
I don't understand the question.
How old's the estate? I mean, when did this person die, and is it wrapped up yet?
It's been wrapped up yet, and according to the will, the people that are involved as beneficiaries are supposed to pay their equal share of the property tax.
Well, but if the estate's closed and everybody's just on a deed now, then you have a different cause of action. That's called that's to enforce your common duties as common owners of the property. So if you've got three people on a deed and you all own it together, absolutely, as like tenants in common, then you have different causes of action for contribution towards maintenance and expense. And then you also have another cause of action called partition to force that person off if they're not going to exercise their contribution.
So if a beneficiary violates...
Well, wait a minute. Wait. We don't let dead people tell us what to do after a certain point. What I mean by that is dead hand control, as they call it, is something why we have the rule against perpetuities, and we just don't trust. We don't want people from 100 years ago telling us what to do today. So once the estate's over and the property's been deeded to various people, right? I assume that's what happened. The estate issued a deed to these people.
Not yet.
Okay, well then the estate's not closed yet.
Pardon me?
Then the estate's not closed yet.
Oh, well, it's complicated. I thank you for the information. I'll have to work on this. Thank you.
All right, good luck.
Thank you. Bye.
Yeah, I don't know what she's talking about. I mean, at one level, is there an estate? Is there not an estate? Is it open? Is it closed? Is it left-handed? Is it right-handed? I don't know what she's talking about. But long and short of it is beneficiaries, if they feel the estate's being mismanaged, do have standing to complain. So do creditors if they think the estate's not being managed properly. Point is you do have rights and options. And then after the estate's closed, if grandma said all three grandkids are going to own this property equally, and one of the kids is a deadbeat not contributing, they're separate cause of action. You don't go back to the estate to handle that per se. you actually would file as one of the grandchildren against, your cousin or brother and complain about it in court. Shirley, you're on WHP 580. My talk line number is 540-0580. You there, Shirley?
Yes.
Shoot. What do you want to say, Shirley? You're on the air.
Yes, I would like to ask what happens when a person doesn't have a will. I have a son that I can't get him to make out a will. He has a common law wife who has 2 children, and he has a child and grandchildren. So I'm wondering what happened.
Well, all kinds of things happen, all kinds of problems. And what I mean by that is the law has provisions, they're fill-in provisions for a will, and they allow you to figure out where all the property is going to go to, assuming that there are heirs. The next question is, who are the heirs? And the minute you bring up the word common law wife, I get concerned because that's going to complicate who the, quote, heirs are or aren't and how this money is going to flow. And Shirley, what I'm going to do, if you'll hold with me, I'm going to go through the break here, and you hold through the break because I want to talk more about this at length. I want to give you a few moments, okay?
Sure.
All right. When we come back from the break, we'll have Shirley and Skip and anybody else who wants to call 540-0580. Hey, you know what I hate, Shane? I hate when you have your desk all organized and somebody comes in there and moves everything all around. Just drives me crazy. Just thought I'd tell you that.
Thanks, brother. But isn't it usually nice how you always have? Why is your desk always unorganized in the first place, though?
Well, a lawyer's desk looks messy, but trust me, we know where everything is, every last thing.
I think that's every profession has an unorganized desk.
I'm nervous about people that have really clean desks. I think they might, be postal or something. And no offense to postal workers by using that. I think it's actually in the dictionary now. Shirley, you're on WHP.
Yes.
My talk line number, just in case anybody else is listening, is 540-0580. And Shirley, you had a question, and ask it again for anybody who's just joining us.
I wondered what happened when someone does not have a will, and they have a child and grandchildren.
And a common law wife.
Common law wife.
All right, well, here's what happens. First of all, whether somebody's a common law wife or not is an interesting question in Pennsylvania. We abolished it in 2004. But if you establish a common law relationship ahead of time, you might or might not be a common law wife. So that's a factual question. Yeah. If he wants her to be treated like a wife, he can certainly marry her. He can also treat her like one in his will. But the Department of Revenue wants her not to be a wife because then her portion of the estate gets taxed at 15% instead of 4.5%. Mm-hmm. And then the children, your biological children and your stepchildren are treated differently under the law. Your stepchildren are not your children at all if you die without a will, whereas your wife is your wife if she's married, or a common law wife if you die without a will, and your natural children are your natural children. And then there has to be a division between, and if that's not the mother of your natural children, then there's a differentiation between your children and her as to how the estate gets sorted out. It's fairly complex, and the word common law wife concerns me because it's going to at least create a 15% tax rate if she's not the wife. And since he doesn't have a will and she's not the wife, it's just going to go to his biological kids and nobody else is going to get taken care of at all. So he really needs to get a will.
Well, I've been after him. I told him I'd even pay for it. So I'll work hard. But I never did know what you told me about what happens if you didn't have a will. That was what was concerning me.
And surely he really needs to do it because otherwise it's just going to be a big hurtful mess.
Right.
And everybody's going to be mad at the biological grandkids because they ran off with everything and there was no provisions left for the wife and all this time they've been together.
Sure.
Creates big family fractures. And so remind him he can go to weekendappointment.com and download a free will from there, which is a kit he fills out. And, he still has to meet with a lawyer and he still has to deal with the fact that he might die someday, which seems to be the big impetus to prevent many people from even thinking about a will.
Sure. Okay, well, I appreciate your helping.
Thanks, Shirley.
You're welcome.
Folks, if you're listening to this show, you're going to die. And it's not because you're listening to the show, it's because you're alive, and at some point, you pass away. And if you don't make provisions, you can leave behind big old messes. Big messes. I have to pick them apart sometimes. Skip, you're on WHP 580 with Carl Rominger.
How you doing, Carl? What type of a lawyer do you go to for finding out information or going along with trying to get guardianship? Would that be like a family practice lawyer?
Generally a family practice lawyer, general practice. Getting a guardianship it depends. I mean, we do guardianships in a couple different scenarios.
Okay, well, just let me give you a little more information. Number one, is it possible to get guardianship for a non-related child, 5-year-old?
Potentially, yes.
Okay, that has to go through court?
Yeah. Oh, yeah.
Okay.
Now, if you again, what do you mean by guardianship? I had.
Okay, the child, the little 5-year-old, is not being cared for properly by the mother. She's a single parent mother, and I've been providing for the child since she's been born as a friend of the family. And there's just things that happen that are not correct.
Well, the short answer is if you've been providing financial support, you might not be in loco parentis, so you may not have standing.
Okay.
The father has standing, the mother has standing, the grandparents have automatic standing.
The grandparents and the father are not involved with the child at all.
Yeah, and so, but the father would still have to be entitled to any kind of notice. She could sign a guardianship over to you to take care of the child, which is basically just a glorified power of attorney so that the school district and whatnot and the doctors know you have ability to work with the child.
I have power of attorney now, but there's really no standing with that.
Right.
The big argument is what the child's been accepted to the Milton Hershey School.
Skip, do you call in every week?
The mom doesn't want her to go, so I'm trying to figure some way to get around this.
Yeah, Skip, the answer is you're going to need to see a family law attorney, but I think you're going to be boxed out. I think Skip calls in. I drop Skip because I think he calls in every week with the same question. And I give him the same answer. Skip, it doesn't change week to week. Don, you're on WHP 580 with Carl Rominger.
Hi, Carl. I'm going through a divorce. And last Christmas, my daughter bought me a 45 automatic, legally registered in my name. My wife and I are still living in the same house. She's taken it out of the house and given it to somebody else. What are my legal options?
Well, okay. The gun's technically marital property because you acquired it while you were married, right?
No, it was a Christmas present to me from my daughter.
Okay, it's a gift, so it may not be marital property. Long and short of it is it's registered to you, right?
Yes.
So a handgun is kind of like titled property. I mean, it's registered to you. Who'd she give it to? Just some random third party?
I have no idea.
You got two options. One is if you're in the middle of a divorce or somebody's filed for divorce, you have the ability to file a petition for special relief, which would be getting a court order for her to return it.
Okay.
And if she won't, at least have the judge force her to divulge who she gave it to. And then you could go to that person and demand return of your property. And if they refused, I think that once they know that it's yours, they would have to return it or they would be subject potentially to criminal liability.
All right. Thank you.
All right?
All right. Thank you.
No problem.
Bye-bye.
All right. See, now that's a question I like. It's answerable. It's straightforward. And he's probably not going to call me back next week and ask me the same question again. Okay, folks, talk line number 540-0580. Don't forget to go to weekendappointment.com. Again, people have been posting questions all week. I got to catch up on a few of them, but we're getting some really good questions. We've got some people doing some political discussion on there. Of course, if you register the registered user area, you get the free will. And under the announcement and events section, if you're a member of an organization, you guys are doing a golf outing or something like that, you can send me an email and I'll let you know how you can get on the announcement and events section and you can put your group's information up there. We have over 700 registered users now, so a lot of people are going to see it. Steve, you're on WHP 580 with Carl Rominger. 540-0580 is my talk line number.
Carl, thanks for this service. My mother passed away in March with no will and basically no assets. The mobile home she lived in had been signed over to my sister.
Uh-huh.
And she really had no bank accounts, no nothing except a small insurance policy. Now that she's gone, is that done, or is there still estate papers that have to be filed with the state, or what do you do in a case like that? Because we haven't done anything, and my brothers say we don't have to do anything.
Yeah, sometimes people come in to see me and they say, Grandpa died. He isn't survived by anybody but me and my brother. He owned a truck that's worth about $500, and some clothes, and that's it. What do we do? And I say nothing, because the expense of opening an estate is usually about $1,000, give or take, if you figure out just all you need to do to open it and close it and file the tax return. And even if everything is as simple as pie, you're probably not going to be able to get a lawyer to do it for less than $1,000. And even if you did it yourself, you're still going to be north of $500 with all the fees and all this kind of stuff. So long and short of it is, usually I tell people, if there's no property that really exists and there's some debts out there, let the creditors open it and discover that there's nothing there. If you owe the state money for medical care or something like that, the state will actually do some research to see if there's any assets, and if so, the state will open the estate to come and get reimbursed.
There were no bills. All her current bills were paid for by my brothers and I.
Yeah.
And the only thing we couldn't pay was a huge credit card bill, which was run up by my sister when Mother was ill, and she's the one that ended up getting the mobile home. So that was really it.
Yeah, then I wouldn't even worry about it. I think your brother's right. Nothing for you to do.
Yeah, okay. Thank you very much.
All right.
All right, take care.
Take care, Steve. When we get into these what I call insolvent estates, that's where the debts – insolvency just means you have more debts than you have income or assets. That's a fancy word for that, which means, you're an American citizen. Well, you're the American government, you're the state government, you're a municipal government. Pretty much everybody's insolvent, but it's a fancy legal term that means you have more debts than you have income. Insolvent estates, don't bother opening them as a general rule. Let a creditor come forward and open them if they think it's worth trying to wring something out of it. Paul, you're on WHP 580 with Carl Rominger. Paul?
Oh, yes. Yeah, I had a glitch there.
That's okay.
My father had a will. Okay, my mother preceded him in death by 5 years. My sister had power of attorney, and his estate was upwards of $1 million. Okay, house, ground,
okay,
etc. And when the estate attorney filed the Pennsylvania inheritance tax return, the only thing listed was stocks and a few bonds. My sister had transferred, using the power of attorney, to herself, okay, in that 5-year period.
Right.
What could be done about that?
Well, whenever a power of attorney makes gifts to themselves, it potentially can be set aside. In fact, there's some court cases that say particularly any gifts given within 1 year of death where delivery was effectuated by the power of attorney to the power of attorney are to be viewed with extreme caution. And it's the burden of that party to assert that there was actually a gift. So now, how has the estate been settled yet, or no?
No. The PA inheritance tax was turned in by the estate attorney, but we haven't heard anything back on that yet. Right.
What you would try to do is get an accounting of the estate. But in the meantime, I would strongly advise you to get an attorney. What we would do is immediately make a claim to say, hey, we don't think this is appropriate. We think there's issues with this property being transferred. And I assume, is this person also, the person who used the power of attorney is also the executrix of the estate now?
Yes.
Yeah. And that's, you want to challenge that right away.
Okay, could that be challenged now, or do we have to wait for the first and final account?
I wouldn't wait that long. I would start making my waves now and file a petition to set aside the gift and yada yada yada, because you already know where the land is.
Yeah.
So you can clearly attack it right away.
Okay, great.
We've done a few of those over the years. Sometimes with success, sometimes not. There's some cases where, obviously the person is of sound mind and they want to keep giving gifts to one of the kids over the others. However, where's the gift tax? I mean, who paid the gift tax on this land? That sort of thing. So your sister may not be in as plumb a position as she thinks she is.
Okay, thank you very much.
All right, get an attorney right away.
I will.
All right?
Yes, sir.
Yeah, if you smell a problem, get an attorney earlier, because even if the attorney determines you do need to wait for a certain event, they'll be up on it. Folks, got to go into break. Talk line number is 540-0580. Welcome back. Carl Rominger here. 540-0580. 540-0580. If you can't get through on the call lines, go to weekendappointment.com anytime between now and forever. Post your question on there. You can also get my office contact information on there in case you want to meet with me in the office. Winnie, you're on WHP 580 with Carl Rominger.
Hi. I hope I can make this question clear without rambling on too much. My husband's parents had property over in another country.
Winnie, are you on a cell phone?
Pardon me?
Are you on a cell phone?
Yeah. No, a regular one.
All right, shoot.
You can't hear me?
I can hear you now.
Oh, okay. My husband's parents had property over in another country. Of course, his parents have long been gone. There's no will or anything. Well, it comes up that it's being sold. They let it go to rack and ruin because they thought nobody would want it. But anyway, it's being sold. Now, he had 2 brothers and a sister, so there were 4 children altogether. Well, the one brother, I'll call him Bob, has died. And so Bob, the brother that died, his children are wanting a piece of the money that's going to be made from the sale of the property. And the other brother and sister and my husband that are still living, then we say, well, then our children should maybe get.
Well, I'm going to explain this to you real simple.
Okay.
It all depends on if the parents died in this country and in Pennsylvania in particular without a will, then it's very simple. Each leg is going to get an equal share, and so the surviving grandchildren of that leg will split that 1/4 share amongst them in an intestate situation. Now, if the parents died in another country or that those proceeds are controlled by the law of that country, it could happen differently. But
well, see, one died in Pennsylvania, one died over there.
Who died last?
Greece. His mother, and she died in Greece.
Yeah, so potentially it's going to be Greek law. Got to get a Greek lawyer over there. All right. I don't know Greek law. It's all Greek to me.
Okay.
All right.
Well, do you think that's fair, though?
Absolutely. Absolutely. That's the way we've always done it.
Oh.
That's the normal way to do it.
Okay.
You're going to inherit it, and then when you die, you'll leave it to your kids.
Yeah.
Well, he just didn't live long enough to leave it to his kids, so it goes straight to his kids.
Well, how about, he had 2 wives. They want a share of it, too.
Well, he had 2 wives. You can't have 2 wives at the same time, Winnie.
Well,
all right, get some lawyers involved in this. Get one overseas and get one local. Good luck. Oh, boy. Oy vey. I don't know about that one. Of course, that's fair. It's called per stirpes. That's the way everybody wants to do it. If you have 4 kids and one of your kids predeceases you and all your kids have kids, that share falls to grandkids, so you don't inadvertently write a set of grandkids out. Rich, you're on WHP 580 with Carl Rominger.
Hey, Carl, never run short on time, so I'm just going to say this real quick. On my primary home, I was not able to pay my 2008 property taxes as yet. I got the certified notice from the county in the end of January, and it says on there that my property, as long as I paid them before July of 2010, my property is not at risk of being sold. And they gave me a payment schedule to pay it.
Mm-hmm.
In the meantime, they notified my mortgage company. My mortgage company sent me a letter in April saying if I don't pay my property tax, that they may pay it on my behalf and then start escrowing my taxes.
Right.
And that's exactly what they did last week. They paid them without telling me that they were going to, and I'm still working on paying it off. And now what they're telling me is my taxes are going to go up by as much as, or my mortgage payment will go up as much as $300, $100 a month to recoup what they paid. Plus, they're going to start escrowing 2009 taxes, and since we're past 09
right.
halfway, they're going to start doubling up my payments. And I can't afford that. And I sent them a letter when they sent me their letter asking them to give me some more time, and I guess they say no. They said they're not going to give me any time. Do I have any recourse to fight this at all?
Well, the mortgage company's concerned because if it does fall into a tax sale at some point, they have to come out and defend, make sure that the property doesn't get sold off to anybody. So they usually end up being the ones to buy it at tax sale for whatever's owed on it. But here's the theory. If you read all that fine print in the mortgage you signed back at closing, you'll see some language in there that says precisely if you fail to pay property taxes on time at our option, we can pay them, et cetera, and they can probably call the mortgage.
Yeah.
So by going to the intermediate route of saying, oh, well, we're not going to call the mortgage, we did exercise our option to pay, but we're not going to call the mortgage as long as you cooperate in this. You probably don't have a great legal foot to stand on. However, I strongly recommend you consider getting a bankruptcy or debtor-creditor attorney, which is another word for bankruptcy attorney, to chit-chat with them on your behalf, because that person can say, now, wait a minute, we can go into a 13. We can't get rid of this mortgage, but we certainly can, give you a little bit of grief and adjustment in the meantime. But I suspect with if they know you're represented, you can probably strike a happy middle ground to catch up on this.
Okay, great.
All right?
All right, thank you so much, Carl.
Thanks, no problem. Oh, boy, bankruptcy. That's a big topic these days. If you're behind, if you think you might end up behind, if you're like a payment behind on your mortgage, or you got a lot of credit card debt and you're running the numbers, don't string it out like 100 years and then go see the bankruptcy attorney, because if you want to keep your house in a bankruptcy, the way you do it is you go bankrupt long before you get way, way behind, and you incur costs and fees you'll never catch up on, because that's how you keep your house in a bankruptcy. So anyhow, I just want to note that. And, of course, obviously, if you go to weekendappointment.com, we got a bankruptcy section. You can get the office contact information off there. And Lee in my office does those, and he's always happy to consult with people for free on whether they need a bankruptcy or not. So if it's a free consultation and you might need one, it's probably worth looking up our phone number and calling Lee. Jerry, you're on WHP 580 with Carl Rominger.
Yes, I have a question about wills. My wife and I have grown children. We don't have a will. My feeling is, if something happens to me, she's going to inherit everything I have. If something happens to her, I'll inherit what she has. The only problem would be if we would die together.
Right.
If we don't die together, the survivor is the one that really needs the will.
Yeah.
Where the two of us, unless we die together, I don't see why we need a will.
Well, it might be real simple. And for some situations it is. You can die without a will and everything just flows downhill like it should, or across just like it should. But for ease of administration, it is easier if you have a will, because the kids then know very straightforward how you guys wanted it to be, which is equal shares. If nothing else, you're just reaffirming that. So if one of the kids gets a notion in their head that somehow they, were more deserving or more needy than the others, they know that you've spoken. Usually what we do, though, for married couples, we write what we call reciprocal wills. It says if you die, it goes to her. If she dies, it goes to you. And then it says if you both die, here's how we want it handled, and here's who we want to be in charge of it.
I see.
And because they're free, if you go to weekendappointment.com, there's no excuse not to have one.
What was that again?
Weekendappointment.com is where you get the free will, Jerry. There's no excuse not to have a free will if you go to weekendappointment.com, fill out the form, and send it in and get a meeting with me.
Appointment.com.
Weekendappointment.com, Jerry. Folks, music means we're out till next week. Go to weekendappointment.com in the meantime. Sign up, become a registered user. I will see you next Saturday at 2 p.m.